stream from here, but we can if we need
Good morning. We're having some technical difficulties. We'll be getting started in a few minutes late. Thank you for your indulgence.
It says it's stream.
Good morning and welcome to the Maryland Public Service Commission's meeting for today, January 25th, 2023. We have a number of the items on our agenda to address today, but I'd like to discuss a topic that I testified to yesterday at the Economic Matters Committee before the Maryland House of Delegates, and that is with respect to retail supply competition in the state and where we are 23 years after the Commission was directed to engage in the deregulation of our utilities back with the Restructuring Act of 1999. Recently, in the past week, the Consumer Affairs Division of the Commission posted complaint numbers with respect to the second half of calendar year 2022. I've had a chance to take a look at not only the public numbers, but the internal non-public complaint data of many of our retail suppliers. And we have several hundred in this state. Retail choice has been the policy of the state for 20 plus years, and this commission has done everything within its power to support the retail supply industry. Most notably, last year, the Commission finalized regulations to enact supplier consolidated billing, which would allow retail suppliers to directly bill customers as opposed to using the utility consolidated bill. Those efforts remain underway. Those efforts are expensive, but those efforts were undertaken to allow retail suppliers to have a direct relationship with their customers, for which they have longed for at least 20 years. When I came to this commission in 2018, I was one of the strongest supporters and advocates of retail choice competition in this state. I've used retail choice, exercised it for my own use for electric and gas purposes. However, at this point now, 5 years later, I am, as I testified yesterday, agnostic on retail choice. Typically, having choices is a good thing. Having more choices than less is a better thing. But what we have here is a commodity, one that is fungible, electrons, gas molecules. So where retail suppliers can compete is on service, other benefits, aside from the sale of the commodity themselves, because we should be honest that an honest retail supplier would be hard-pressed now to earn a significant profit simply based on the sales of every kilowatt. It's oftentimes hard to beat the standard offer service rate, the default rate that is offered by the local distribution utility, whether it be electric or gas. I am proud of the fact that this commission back in 2019 created a compliance and enforcement unit to investigate and, where necessary, prosecute retail suppliers that have engaged in deceptive market manipulation, that have been in violations of COMAR in Title 20, Subtitle 53. And we've launched so many actions over these years, including against entities such as Smart Energy, Smart One, where we revoked the license, Statewise, Atlantic, Direct, Maryland Gas and Electric, and others. I was hopeful that these activities that we committed untold resources to, in partnership with the Office of People's Counsel and the Maryland Attorney General, that we would have seen an abatement in terms of the number of complaints that we receive at the Commission every month. That does not hold true today. While there was a slowing of complaint numbers during COVID because of restrictions on door knocking, we've seen a spike in complaints, unfortunately, towards the second half of last year. This is more than just patterns and practices. This is more than trends. I see a story here. And this document reflects what's on our website. And the story is not good. As the public should be aware, we publicize on our quarterly report cards when a supplier triggers 3 or more complaints per month in a given month. Once hitting that mark of 3 complaints, the identity of that supplier is made public. Of course, the larger the supplier, the chances of more complaints being lodged would seem to make sense. And each of these reports includes a disclaimer in terms of whether or not resolutions have been reached and in which party the Commission finds favor with, either the consumer or the supplier. There are plenty of times where the customer inadvertently makes the mistake or the error. But there's plenty of times when the Commission has found in favor of the customer, finding that the retail supplier engaged in some type of a deceptive practice, that they perhaps slammed the customer and transferred service unknowingly, or violated a term of COMAR. We've done a lot. I'd like to credit this commission in terms of creating the 3 new websites, including the landing page at mdenergychoice.com. We've emphasized a culture of compliance, and that's stuck with some of our retail suppliers, but not all of them, unfortunately. And I hate to paint the industry with a broad brush, and that's not my intent here. But we do have bad apples within the retail supply community, and they're ruining it for all the other reputable suppliers that operate in the state. I've asked reputable suppliers to drop a dime on their competitors that they know are engaging in these practices. I've asked companies to self-report violations when they internally determined that they violated COMAR. And to their credit, some retail suppliers have come forth, admitted guilt to the commission without the commission discovering it first. These complaint numbers, though, and I would ask everybody to take a look at them for themselves, are disappointing. And they're disappointing because they're names of retail suppliers that we've seen before. And some of these retail suppliers may not have gotten the message. So what I'm going to read are some just factual data points that is publicly available on our website now. Over the second half of calendar year 2022, the retail supplier by the name of Sunsea Energy, Maryland, a retail supplier that we are well familiar with, has incurred no less than 36 complaints. SFE Energy Maryland has incurred no less than 22 complaints. Major Energy Services, LLC, incurred no less than 19 complaints. Inspire Energy Holdings doesn't inspire much confidence with 18 complaints. Indra has no less than 14 complaints. That's Indra Energy. And then Clean Choice Energy Incorporated incurred 12 complaints, no less than 12 complaints over the course of 2022. And I say no less than because these companies could have incurred additional complaints that did not come across the public reporting screen. Because of these increased complaints, and because this commission has an obligation to ensure that the public is protected, I'm announcing that the commission will move to a phase of maximum enforcement. That phase will begin on February 1st and last for a period of no less than 6 months, at which time I will marshal resources within this agency to support our Consumer Affairs Division, to support our Staff Counsel's Office, to ensure that the Commission is investigating and, where appropriate, prosecuting retail suppliers. The Commission easily, or at least in the past, has easily approved supplier licenses at administrative meetings. More recently, we've rejected on the spot many retail supplier license requests where we did not feel that the licensee applicant had the fitness, background, or met the requisite requirements in order to gain a license in the state. And I've been proud of my colleagues as well as the Commission staff for scrutinizing these applications. That said, once a licensee has a license, the Commission has no policy in place to revisit the license requirements or the activities of licensees. One of our regulations that is frequently flaunted and violated is regulation number 13. That's in Title 20, Subtitle 53, Chapter 7, which requires that the retail supplier provide notice at least 12 days in advance of a rate change. This is particularly important when customers are on a variable rate plan. For those who remember, back in the summer of 2018, I announced that I was on a variable rate plan and noticed that I had a 72% increase that occurred. And I blame myself. I knew the contract terms. I knew that after 3 months the teaser rate would disappear and a month-to-month rate would increase. I have not heard very many success stories where customers have benefited from a variable rate. Unless the customer trades platinum or palladium in the NYMEX pits, I don't think they have the requisite background in order to trade a commodity. So this maximum enforcement effort will begin on February 1st. The Commission, as the licensing body here, has the ability to revoke a license, to subject the supplier with the license to civil monetary penalties, and we have not hesitated to do so in the past. We have the ability to direct refunds, and we're serious about this. I'm particularly proud of our General Counsel's Office. More recently, they have been litigating these cases tooth and nail in the circuit courts, in the Court of Special Appeals, and very soon in the newly named Supreme Court of Maryland, where we will be litigating against one of our licensees that goes by the name of Smart Energy. This is serious business. This is one of our core functions, to protect the public. And sometimes it feels like I'm emptying a cesspool with a teaspoon, but we're taking this seriously, and we're going to to ensure that customers are protected. Thank you. Commissioner Richard.
Thank you, Mr. Chairman. And Mr. Chairman, I just wanted to, publicly state I applaud you for the statement you just made, and I want it to be known that, and publicly known that I support everything you just said. I think it's important that we remember these are essential. Energy services are essential to our Maryland customers, and it's unacceptable to see any gouging or any kind of deceit that could deprive these citizens of these essential services. So, and I would also note that we have a lot of important work to do here with regards to clean energy, energy justice, conservation, and this is just an unacceptable distraction that we have to continuously see what's going on the retail side. So I think it is important that that these companies that are flouting our laws stop doing business in Maryland, and I stand with you and anything we need to do to make sure that they are no longer doing business in Maryland. So thank you.
Thank you. Commissioner Linton.
Thank you, Mr. Chairman. So for those of you who might know a little bit of my background, you know that I come from the Consumer Affairs Division. Before that, I had my own law firm, and I actually represented some suppliers, none of whom the chairman mentioned this morning. So I'm at least happy about that. But in working in the Consumer Affairs Division here at the Commission at the time called OER, I've been seeing this challenge of working with some of our deregulated marketers for a long time. So I'm looking back over a decade now. And while some of the names have changed, the issues have largely kind of repeated themselves and remain the same. I can recall back in 2012 when the first polar vortex hit in New England as opposed to Maryland. And we saw the variable rate prices increase dramatically there. We also had customers in Maryland who were impacted by it. And so we actually, one supplier who the commission ultimately did issue a complaint against, provide testimony on the record here in front of this commission in their defense, openly claiming and making clear to us that they, for lack of a better word, use Maryland customers as a backup wallet for investments that they made in New England that failed. There were very significant energy justice and basically outright discriminatory actions in that regard, in the sense that their primary marketing efforts were largely through the urban regions of Maryland and in the District of Columbia. At the time, they were using our tariffs and our regulations effectively, using them against us, forcing customers to remain with them even when the customers attempted to switch. And all of this is in the record. I'm not telling you anything that's confidential or embellishing in any way. These are actions that they took, and they were not concerned about it. So even though the commission fined them, at the time they retained their license, continued to charge customers more than much more than what they were paying in the commodity rate. And I point all of that out because the next year and the next winter, the polar vortex hit the PJM region. And that's the period of time which we now refer to, of course, as the polar vortex period. And the resultant numerous, literally thousands of complaints that were received from customers who were on variable rate contracts. And those, of course, resulted in some customers paying 6 and 7 times the standard or default rate offered by the utility. They received those bills, as the chairman mentioned here, without any notice. There was no mechanism in our regulations to allow the customer to actually switch away from the supplier. It took 2 to 3 months to do so. And by the time you finished, you received several of those large and, in many cases, unconscionable bills. I actually saw one bill from one supplier that was at 98 cents per kilowatt hour. That never made it as a complaint here because In my capacity as director of OER, I called people that I knew in the industry and basically told them, you are going to tell this supplier to revoke this bill. And that's going to be the end of it. There's not going to be a complaint or investigation or anything. And so I was able to handle that a different way. So I had to do, sometimes those kind of conversations have to be had, and they're not pleasant to talk about. But I tell you that because that's the way in which we had to address some of these problems so many years ago. So I was very happy to see that the commission moved forward with the Rulemaking 54 process, which attempted to address many of these challenges. At the time, the Office of People's Counsel, many of the deregulated marketers in the state are utility companies, and many residential consumer advocates all participated in that process and adopted a number of consumer protections that we look at today. And we know those help to lower some of the complaints that we've received. But that was close to 7 or 8 years ago now, and the industry has adapted again. And so we find ourselves back in a similar situation as what we saw several years ago, where complaints are starting to increase, and at a time when the economy is challenging, the price of commodity rates are high, the promise that we had for the deregulated market is still out of reach. So I still think there's benefit, there's opportunities and ways in which suppliers can benefit consumers in our state. I do not think that all of the suppliers that we have as licensed companies in our state either see that benefit or are interested in pursuing it here for the citizens of Maryland. I think they see us, as suppliers have in the past, as a backup wallet or as a pocket that they can take advantage of, get as much as they can, and then move on. They may not even have an office here, for lack of a better word. So I'm pleased, Mr. Chairman, that the Commission is taking a more aggressive approach here. Personally, I think there's quite a few things we could do to be even more aggressive, and perhaps we'll explore those things over the course of the next several months. But I think it's unfortunate that we find ourselves back in the same position. I feel very concerned about those customers that are receiving those larger bills and don't have the knowledge of how to move forward with a way to protect themselves and to make sure that they don't find themselves in a situation where their service could be exposed to service denial. So there remains even more work to do, and at some point, all of these holes in the dam have to be plugged. So I'm not sure where it's going to end up at, but I think that this is a good step.
Thank you, Commissioner. This commission benefits from your wealth of historical and institutional experience. Commissioner Boomer.
Thank you. Chairman, I wholeheartedly support all of your comments and the actions we're taking. And I too was, I took advantage of choice prior to coming here, prior to even understanding everything that I know now. And luckily it was a fixed rate contract. It was very beneficial. But since I came here and I don't have the benefit of the long history that my colleagues have, this has been something I've really wanted to better understand. So I asked to meet with the retail supply trade associations. I spent 3/4 of a day with one of the consumer advocates in downtown Baltimore, just trying to understand how these people operate and what are some of the opportunities to stop it. I agree with Commissioner Linton. I think there's more that maybe we should consider doing, and I look forward to partnering with OPC to see if we can identify if there's more, and I hope that the appropriate people who need to hear this message are listening to this today. Thank you, Chairman.
Thank you, Commissioner. There is more to come. We do have meeting minutes to approve from our last meeting 1 week ago, January 18th. All in favor, please say aye.
Aye.
The meeting minutes from our last administrative meeting are approved. Good morning, Madam Secretary.
Good morning, Mr. Chairman. There is one item on the consent agenda. Item number 1 is a notice of the transfer of control of certain assets from VDL Inc. to Xtel Communications Inc.
Thank you. Seeing no questions, I would move that we note the transfer of control of certain VDL Inc. assets to Xtel Communications Inc. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Mr. Chairman, item number 2 on the administrative agenda is revised tariff pages from Potomac Electric Power Company for the contribution in aid of construction for certain schedules.
Good morning, Mr. Gregor.
Good morning, Mr. Chairman. I believe Mr. Hoppick is on the line and will be doing the presentation this morning.
Hello, Mr. Hoppick. Oh, Mr. Hoppick, you might be on mute.
I'm not.
Oh, there you are. We hear you now.
Okay, thank you. Apologies. Good morning, Chairman and Commissioners. David Hoppick on behalf of staff. Per the Phase 2 settlement agreement in case number 9217, PEPCO has filed updates to its contribution in aid of construction, or CAC, costs for non-LED streetlights in Schedule SSL-OH, streetlights served from overhead lines, and Schedule SSL-UG, streetlights served from underground lines. These CAC costs are paid by customers to install, remove, or convert a streetlight from one wattage to another. As noted in staff's comments, the listed Schedule SSL-OH CAC costs apply solely to high-pressure sodium all standard wattages, whereas the listed Schedule SSL-UG CAC costs are for all standard types and wattages. In a data request response, PEPCO stated that the label for the listed CAC costs for Schedule SSL-UG should be changed to high-pressure sodium all standard wattages. The LED streetlight classes, Schedule SSL-OH LED and Schedule SSL-UG LED, both have CAC costs to install, remove, or convert an LED streetlight, but do not have a table of listed costs. After discussions with staff, PEPCO has agreed to propose listed CAC costs for the LED classes, including a listed CAC cost to convert a high-pressure sodium streetlight to an LED streetlight. Staff recommends that the Commission accept the updated CAC costs with the tariff revisions proposed by staff, require the company to file clean copies of its tariff, and require the company to file within 6 months of the letter order for this filing proposed CAC costs for Schedule SSL-OH LED and Schedule SSL-UG LED, including CAC costs for conversion of high-pressure sodium streetlights to LED streetlights. Thank you. I am available for questions.
Thank you, Mr. Hoppick. We'll turn to counsel for PEPCO. Mr. Michael, good morning.
Good morning, Doug Mikeel. I have nothing to add. We worked collaboratively with staff. We plan on complying with the 6-month filing and making the changes that are outlined in the buck sheet. Happy to answer any questions, or I do have a subject matter expert here if you have questions.
Thank you, Mr. Michael. Do my colleagues have questions on this item? Commissioner Bubar.
Just one question, and maybe it's for PEPCO. Just wanted to make sure, is the relevant data available to be able to comply with the request that's due in 6 months in terms of having the relevant costs?
Yes.
Okay, all right, thank you.
Seeing no additional questions, I would move that we accept the updated contribution in aid of construction costs with the tariff revisions proposed by staff in its comments dated January 18th, 2023. That we direct the company to file clean copies of its revised tariff pages, and that we direct the company to file within 6 months proposed CAC costs for schedules SSL-OH-LED and Schedule SSL-UG-LED, including CAC charges for the conversion of the high-pressure sodium streetlights to LED. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Mr. Chairman, item numbers 3 and 4 on the administrative agenda are revised tariff pages from Delmarva Power and Light Company and Potomac Electric Power Company for their Green Rider rates.
Thank you. Good morning, Ms. Shaw.
Good morning, Chairman and Commissioners. Paige Shaw on behalf of staff. On December 22nd, 2022, DPL and PEPCO submitted proposed tariff revisions to their Green Rider rates to reflect up-to-date renewable energy credit market prices. The rider provides 100% renewable energy, and it is voluntary for the plug-in vehicle and residential plug-in vehicle rate schedules and mandatory for the public charging plug-in vehicle rate schedule. The proposed rate is 0.02109 per kilowatt hour, which is a 5.7% increase over the existing rate of 0.01996 per kilowatt hour. Staff recommends that the Commission accept the tariff pages for filing with an effective date of February 1, 2023. And I'm available for any questions.
Thank you, Ms. Shaw. Was that for both items?
Yeah.
Thank you. Mr. McKeel.
I have nothing to add. We agree with the staff's buck sheet and appreciate their work.
Thank you, colleagues. Seeing no questions, I would move that with respect to item number 3 and item number 4 that we accept the tariff revisions for filing with an effective date of February 1st, 2023. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Mr. Chairman, item number 5 on the administrative agenda is updates from Potomac Electric Power Company to its base distribution offset riders under order number 89868.
Thank you. Good morning, Mr. Justy.
Good morning, Mr. Chairman and Commissioners. Anson Justy on behalf of staff. On December 15th, 2022, Potomac Electric Power Company, PEPCO, filed revisions to its electric distribution tariffs, updating its base distribution revenue offset riders and its economic relief and recovery rider, which provides temporary rate offsets to customers by accelerating certain tax benefits. The offsets were initially developed as part of PEPCO's current multi-year rate plan as a method of offsetting distribution rate impacts during the COVID-19 pandemic. The 3-year rate plan offset 50% of the rate year 1 incremental rate increase between June 2021 and March 2022, and 25% of the rate year 2 incremental rate increase between April 2022 and this March 2023. The company is proposing to reduce the offsets to 0 and charge customers the full approved rate year 3 distribution rates. Staff agrees because the COVID state of emergency in Maryland has been lifted since July 1st, 2021. The Commission has discontinued its moratoria on service terminations for non-payment. The rate year 2 offsets had been previously designed to produce roughly equal bill impacts for customers in rate years 2 and 3, assuming no offsets in rate year 3. And we believe it's appropriate for full distribution rates to become effective before the next MYP. Because the offsets are funded by accelerating tax benefits, future ratepayers would feel the effect of accelerating additional tax benefits to continue the offsets. Without the offsets, staff estimates the average residential customer would experience a 6.26% average monthly distribution bill increase. The company has planned to provide customers with mailed bill inserts for March, 1 month before the rates are proposed to take effect. Staff recommends the Commission accept the tariff revisions for filing with an effective date of April 1st, 2023.
Thank you, Mr. Justy. Very comprehensive buck sheet, and we did see the draft bill insert. It's hard to believe that PEPCO filed its MYP in 2020. Is that right? 2020, 3 years. It felt like yesterday. Well, I expect we'll see you again soon then with the next rate case. Mr. McKeel.
I have nothing to add, Your Honor.
Thank you. Colleagues, questions? Commissioner Bubar.
I really have one question. Maybe this is for staff. I don't know. But can you provide more information on the reason for the 4.8% increase to the TM-RT schedule? Just was wondering why that was hit harder than any other.
In terms of the kilowatt hour charge, or?
Yes, sorry. I was just curious.
I think I'd have to look into that and get back to you on it.
Okay, thank you.
Can you shed any light on that?
Let me see if Mr. Bonikowski can shed any light on that.
Well, we'll put Mr. Bonikowski on the spot. It's always good to have him back at the commission.
Good morning,
Chairman and Commissioners. Matt Bonikowski on behalf of Pepco. Just give me a moment. I'm refreshing myself on the filing that we had made here. Yeah, all I can say is this would be related to the revenue allocation that was approved in the rate case. TMRT only has a customer charge on the bill. There is no volumetric or demand charge. So this would just be a straight increase in the customer charge there, but I don't have any details.
Okay, that makes sense. All right, thank you.
Mr. Bonikowski, are there many customers on the TMRT schedule?
TMRT is only Metro.
Metro?
Yep.
The-
So it's all the Metro stations and service points.
Oh, interesting. All right, thank you. Seeing no additional questions, I would move that we accept the tariff revisions for filing with an effective date of April 1st, 2023. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner Richard.
Aye.
And I vote aye. The motion is approved.
Mr. Chairman, item number 6 on the administrative agenda are revised tariff pages from Baltimore Gas and Electric Company to true up the administrative charge rates under Rider 1 of the company's electric service tariff, revised time of use standard offer service energy rates, and clarify language regarding standard offer service market-priced service selection.
Good
Thank
morning.
you. Go. Mr. Delgado, good morning.
Good morning, Mr. Chairman and Commissioners. Eric Delgado on behalf of staff. On December 21st, 2022, BGE filed revisions to its electric service tariff to reflect the true-up of the administrative charge under Rider 1 standard offer service for residential Type 1, Type 2, and hourly customers. The administrative charge is subject to adjustment every 4 months to reflect the estimated cost of providing electric service. The administrative charge consists of 5 components, of which 4 are being updated in this filing. These include the incremental costs, uncollectible costs, cash working capital, and the return component, which is updated annually. The return component is increasing for all service classes between 0.05 mils per kilowatt hour and 0.44 mils per kilowatt hour. The main drivers for the increase in the return are the increase in the volume of megawatt hour sales and the cash working capital component of the return calculation. The updated return component is the main driver for the increase in total administrative charge for all service classes except the residential class, which has incurred a decrease in the amount of uncollectible costs. As a result of the true-up, residential customers with usage of 1,000 kilowatt hours can expect a monthly bill decrease of 43 cents for the period February 1st, 2023 through May 31st, 2023. Additionally, energy rates for time of use residential and Type 1 service classes have been shaped based on the procurement bid results on October 17th, 2022 and October 31st, 2022, which were approved on October 21st, 2022 and November 3rd, 2022 in order numbers 90393 and 90406. For the period June 1st, 2023 through September 30th, 2023, on-peak rates for Schedule EV would decrease by 13.37% and off-peak rates would decrease by 8.42%. On-peak rates for Schedule RD would increase by 8.08% and off-peak rates would increase by 2.43%. BGE also proposed tariff language revisions to elucidate the requirements for SOS market price service type selection, specifically for Type 1 and Type 2 service to comport with order number 88102. For example, instead of listing characteristics a customer may not exhibit for Type 1 service eligibility, the refined language lists the Type 1 restrictions as the benchmark for Type 2 service eligibility. The change in tariff language would not affect BGE customers' SOS market price service type. Staff recommends the Commission accept for filing the revised tariff pages with an effective date of February 1st, 2023. And thank you. I'm available for any questions.
Thank you for that presentation. Counsel for BGE.
Good morning, Chairman Stanek and Commissioners. Beverly Sokora on behalf of BGE. Only comment is to again thank staff for their thorough review. It always helps me to understand what we're doing in our filings. And then I'll just say that you will be seeing us probably sooner than PEPCO for MYP2, so more to come.
Thank you, Ms. Sikora. The whole point was to space out the rate cases, but they seem to be getting closer, at least in time, although we only have to suffer through the pain once every 3 years, as do you. Thank you for your recognition of staff. We have so many junior employees that are doing a tremendous job, like Mr. Delgado on these buck sheets and these summaries. They're under the tutelage of more experienced staff, including Mr. Hoppick, who is a remote employee at this point, but I can't be more proud of the many junior staff, particularly on technical staff that work with our utilities and our filing parties every day. So thank you for saying that. Thank you. At this point, I will call a motion unless there's any questions. Seeing none, I move that we accept the tariff revisions for filing with an effective date of February 1st, 2023. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner Richard.
Aye.
I vote aye. The motion is approved. We have one final item that Madam Secretary will call. It is a status conference.
Thank you, Mr. Chairman. Item number 7 on the administrative agenda is a status conference for Potomac Electric Power Company's streetlight tariffs.
Thank you. Parties who wish to make themselves comfortable at the table may do so now. If other parties not interested in this proceeding, you may leave the room at this point. We'll take a 2-minute recess.
It's a status hearing. So.
At last, pardon me. The last time we were all together was back in October. The parties had some homework assignments. My memory fails me as to what all of those assignments were, but I appreciate that PEPCO, Chevy Chase Village, and the city of Gaithersburg have filed pleadings to refresh that memory. So let's begin by taking appearances, and we'll see where we are. This is a status conference. This is not a hearing today. We'll start with Mr. Mikeel.
Douglas E. Mikeel here on behalf of Potomac Electric Power Company, Your Honor.
Thank you. We'll now start at the table, beginning with you, ma'am.
Virginia Casada, I'm the chair of the lighting committee from the town of Washington Grove.
Thank you, Ms. Casada.
Sue Ellen Ferguson here on behalf of the Chevy Chase Village.
Thank you.
Andy Leon Harney. I'm here on behalf of Section 3 of the Village of Chevy Chase.
Ms. Casada, was your document only one page?
I sent I didn't send a document this time. I did send a document on the other two tariffs.
Okay, thank you. We have those older documents.
You'll have the older documents, and then Dave Cosen, who's a town councilor, sent a document forward as well that should be in your...
Okay. I do have one document filed by somebody, mail log 3000991, that has no name on it. That's the mystery document. Madam Secretary, are you aware of that one item? I'm just trying to figure out who it belongs to. It's the last item at the very bottom right of what's on the screen, the television monitors.
My guess is that's Mr. Woodbury, Your Honor.
That's probably Mr. Woodbury, who's on his way from the airport. He called me almost 40 minutes ago, so he may be having trouble getting in downstairs.
Okay, all right.
He's on his way.
Well, now that we know who it belongs to, that's good. Okay. I only have one page, basis of sale. Okay, well, we'll figure this out. Well, let's continue with appearances. We have Ms. Hardy. We'll go to Mr. Greger.
Good morning, Mr. Chairman, Commissioners. James Greger on behalf of staff.
Thank you. Anybody else participating in this proceeding today? Okay, Mr. Woodbury may join us. He may not, depending on traffic. Mr. Mike Heel, why don't I start with you? I read your letter dated the 23rd of January. I reviewed all of your slide decks. You appear to have a more optimistic tone, although you recognize that we may need to move to a contested proceeding at some point. So we'll hear from you first.
Yes, I don't want to replow what's in my letter. I'm assuming that everybody has read that. We've had 3 meetings. We sent out a survey. We've had some one-off meetings with various municipalities. But I think the key takeaway and the progress, if you will, that we have made is on January 9th, we got markups of at least the initial comments that certain municipalities had, and I can't say it was all of the municipalities, but at least a group of municipalities had on the model pole attachment agreement and the model purchase agreement. PEPCO is looking at those, and consistent with what Ms. Ferguson said in her letter on behalf of Chevy Chase View in the near future, i.e. next month. Next month is next week. First part of next month, we are going to sit down with a small group and attempt to hammer out agreement on the topics that we can on the model pole attachment agreement and the purchase agreement. I realize that the municipalities had a list. I think the Chevy Chase View list had 13 items on it. I think that was consistent with the list that the city of Gaithersburg had, and we would work through those issues. I think there's room for us to agree on some of those topics, but I want to be candid, and I think I was candid before this status conference and in my letter. There are probably going to be issues that we cannot work out and that will have to come to this commission for resolution. But my goal is to work out as many issues as we can before we get to that point.
Thank you, Mr. Mike Hill. That came through loud and clear in your letter, and I agree with you. That is the most expeditious way to go. To the extent the parties want a little more time to iron out these issues, they'll be given that time. There are issues that it appears that the parties have reached an impasse, and for better or worse, the commission will get involved. You might not like our decision, either ladies at the table or Mr. Mike Hill, but that will be the final word.
And Your Honor, just with respect to the city of Gaithersburg, we are having a meeting with them.
Where are they? Are they here today?
No, they are not.
Why not?
I don't know.
Okay. Well, it's really hard to take the city of Gaithersburg seriously when, I mean, we have the letter from Mayor Ashman, but the fact that they're not here to represent their interests, I might as well set aside their pleadings.
We do have a meeting with them scheduled for Friday. I think I said tomorrow. I'm losing track of my days. For Friday, and we have been working through the billing issue. It was a manual issue, and I think we're going to have that resolved. And then the rest of the letter relates to, issues that we will work through in the small group related to the purchase document and the pole attachment agreement.
Thank you, Mr. Mike. We have both the red lines for the sales agreement and the pole attachment agreement before us. Thank you for having the 3 meetings that the commission requested from the bench, as well as it looks like 5 additional one-off meetings, and it sounds like more meetings to come. I am a little tired, though, of municipalities who seek action from this commission, but don't appear to represent their interests when we have a hearing that's been scheduled for, well, I should ask Madam Secretary, have you heard from the city of Gaithersburg?
I have not, Mr.
Okay,
Chairman.
well, that I'm glad the 3 of you are at the table to represent your municipalities. This happens time and time again. We see it with the city of Hagerstown and others, that they're not here, and we can't ask them questions. I don't know where the mayor is, but we know Mr. Woodbury at least is trying to get here. Ms. Casada.
Me first?
Well, what's
I was just,
no? What would you like to share with the commission today?
well, I was sort of hoping to go after Sue Ellen.
Okay, Ms. Ferguson.
Ms. Ferguson first.
Thank you. Mr. Chair, Commission. It's unfortunate that Gaithersburg isn't here today, but based on the letter and what I saw in the letter, they share some frustrations that we have.
Not as much as you do, because you appeared today and they did not.
I don't know that they quite understand that. This experience before the Public Service Commission is new for us as municipalities. And so I will certainly pass that on to them, that if they wish to be heard, they need to appear. So we appreciate the fact that PEPCO has taken the efforts that it has. I think it's been an effort that also educated them as well as us in terms of putting together a pole attachment agreement for this purpose, a sales agreement for this purpose, and in being able to at least lay out how they come to certain conclusions and how they come up with certain numbers, which has been helpful to us. It's been a learning process for us. I think it probably has been for them too. We are now fully educated as to PEPCO's position. And we made our list so that it was clear to them again. I mean, we've been commenting all through these meetings, and people have been participating, what the interests of the municipalities are. It has been a little difficult because we are so disparate to come together, but we did find a way of at least getting 5 or 6 municipalities together, the ones most in position possibly to purchase their lights, or at least aware of that fact.
Ms. Ferguson, can I ask you, are you retained, well, you're retained counsel for Chevy Chase Village. Do the other municipalities, do they have counsel represented?
They do not.
So you're effectively the lead attorney for the municipalities. Do you view yourself in that position?
I can say that I have shared with the group everything that's been filed for you, and no one has, in fact, everyone has said this is okay with us. Municipalities act as a council, and so the negotiation part is a little different because you have staff coming in or council members, and there's no final yes until it comes up to a full vote. But yes, I do feel that the views that I have presented to you are shared by the people here and others.
Thank you. And just to be clear, in reviewing the pole attachment agreement and the sales agreement, the red lines, are those yours?
Those are mine with advice from others, including Mr. Woodbury.
Okay.
And comments that were made by various people here and others.
Thank you. So the little comment bubbles, they should not necessarily be attributable to Chevy Chase Village.
Correct.
Okay, thank you. Sorry for interrupting, but I wanted to know who was redlining the document, and obviously a very competent attorney you were. So, thank you.
Well, thank you. So we're at a stage now, and you're going to hear some frustration here because we haven't resolved very much. We see where the original template agreements came from, and then they were adjusted, frankly, to a total Pepco point of view. And we have commented on that. So at this juncture, these kinds of meetings that we have been having, I don't think are useful. We are fully educated as to Pepco's position, and I think Pepco is fully educated as to its position also. So now we need to get into a smaller group to actually negotiate and see if there's any room for anyone to move off of some of these positions. We're speaking from experience of Mr. Woodbury, who helps run these systems in the Northeast, and are informed by that. So we would like to have more of an opportunity to talk. I agree there are going to be some things we're not going to agree to, and we'll be back to you.
Well, I appreciate hearing you say that everybody knows what page Pepco's on, 100%. So it appears that the time has been well spent up until now. We're at a crossroads at this point as to whether we have more status conferences, which I don't believe we should. There will be some litigated items, no question here, just based on a review of the two redlined documents. Do you agree with Mr. Michael that we should use another month or two with a report back to the commission in March, trying to reconcile what you can, and then bring us your list, which you currently have 13 items. Maybe you could reduce that to 12.
Hopefully.
Are you in agreement with Mr. Michael that you're seeking additional time?
Yes, I think it's worth the effort to try to fine tune what's in the agreement. I see Mr. Woodbury is here. What's in the agreement, and also the side issues that come up with that. And as we know, whenever you're sitting down to negotiate an agreement, other things come up because you're walking through how something would actually work.
Undoubtedly, but hopefully new doors don't open and rabbit holes appear where we could actually begin to resolve whatever remaining disputes are on the table for you. Okay, thank you. Anything else, Ms. Ferguson?
No, thank you.
Thank you. Ms. Hardy?
I'm glad that you want to schedule something in March, but I think something that would be helpful for all of us as we go into these negotiations is something I've suggested to Pepco before, and that is that they do a process guide from the very beginning. This is what we would like to see happen. This is how much it will cost. The next thing a municipality has to do is this. This is how much it will cost. And take us all the way through the process, because as you recall, in October, I pointed out all the unknowns that we didn't have price tags for. We had no idea. There may be more. For example, it was unknown to all of us who've been meeting with Pepco on a regular basis that they were proposing a new kayak for conversion from HPS to LED. How is it that we're finding this out sitting here?
Well, I understand your point, the sort of the step-by-step guide. Pepco hasn't had that. The municipalities at the table are effectively the ones working through this process, and hopefully at the conclusion of this, Pepco will have developed that guide. I do not believe Mr. Michael is going to provide that.
He hasn't even answered the questions I asked on October 12th, which I put in writing in December and asked them for a response in writing. I've had can't we have a meeting and talk about this, which I had, but I still haven't gotten any response to those questions that were put to them, and I specifically asked that they be in writing, and they said yes, they would, but they have not.
Mr. Michael, do you have outstanding interrogatories from Ms. Hardy?
December 20th.
You sent them on December 20th?
I did.
Okay, to who?
To all of you got a copy of it, and to Mr. Lapari and others
How did we get a copy of it?
I emailed it, and
We don't have email.
you don't have email?
No.
Okay, well then
we
you didn't
don't.
see it.
We didn't get it. To Ms. Ferguson's point, municipalities are not often before this agency. We are a court, effectively, in this proceeding. We cannot receive information via email. It all has to be filed transparently on the record. Otherwise, it's not received. Mr. Michael, do you have...
I'm going to let Mr. Lapari respond to that. He's leading up this effort.
Okay, all right. Mr. Lapari, can you enter an appearance?
Yes, good morning. This is Paul LaParry, Pepco Holdings. We did have a meeting with Ms. Hardy earlier this month. We reviewed all her outstanding questions in detail, and we had committed to, getting her her follow-up in writing. Just haven't had that chance to do it as we met last Tuesday. Hope to have that to her yearly part of next week.
All right, Ms. Hardy, you didn't provide me with all of the facts. They spoke to you and they said they're getting you your responses. Is that right?
Yes, except that I made my inquiry in October, then here in front of everyone, and then I sent an email to them December 20th. And if by scheduling a meeting last week with me, which I said wasn't necessary because I wanted it in writing, but they insisted, they bought themselves some time, I still haven't gotten it in writing.
Okay.
So it's over a month.
You must have asked some really tough questions.
No, they're the same questions that you got
All right,
on
Ms.
October 12th.
Mr. Lapari, you'll be getting Ms. Hardy responses.
Yes, Mr. Commissioner. And from our standpoint, we always wanted to have a discussion with Ms. Hardy in person, as that one-on-one working through her concerns versus just having an email or letter going back and forth.
I suspect Ms. Hardy wants to have a chain of documents. But I appreciate the sitting down with those who are receptive to sitting down with you. Okay, we'll go back to Ms. Casada.
Okay. To the Public Service Commission and to the staff, I thank you for this opportunity to testify. My name is Virginia Casada, and I'm the chair of the Lighting Committee of the small town of Washington Grove. Washington Grove is a very small town, about 200 residents and 100 streetlights. We are on the National Register of Historic Places, and our lighting is a feature. It's in our historic designation. We value both the preservation of our historic designation as well as the economies of modern streetlights. So we initiated 2 conversions of our very old, our streetlights are like from the 50s and 60s. I'm still trying to date them, but the people in Pemco, they're Pemco fixtures out of Philadelphia, and they're like, whoa, these things are so old. However, they work for us, all right? So we converted them in 2012 in cooperation with Pepco, converted 93 of them from incandescent to induction bulbs, screw-in bulbs with existing fixtures. Our annual rate went from $20,000 a year down to 10, okay? And then in 2020, we did another conversion in cooperation with Pepco. Now, we initiated these conversions, and we paid for them, okay? And we converted to LED screw-in bulbs. And that made our annual cost go from $10,000 to $5,000. Now, we're a small town, all volunteer-based. So we were happy with these lights, and I'm like new to this chair position. So I talked to the current regional director, and I said, I'm hearing that some people are buying their lights. Would that be a possibility? They're no use to you guys, right? And he said, we've been to Washington Grove. It's too dark. Your job as the new chair is to prepare people for a change. We're going to change that, right? And we're never going to sell you your lights. I'm not the only one who heard this, okay? There are other witnesses to this.
Who said that?
This is Tony Ruffin. Anyway, so then I discovered, this is in 2020, we converted these lights, that there was this new tariff coming out. We had just converted to screw and LED bulbs, but it wasn't clear if we were one of the exempted 1,850 something street lights that were we really LED. I asked our new representative, and he said, we'll tell you after the tariff goes through. That was cozy, right? So we started to say, well, maybe we need to be a little more proactive here. Because if this tariff goes through, after a 3-year grace period, we're going to be forced to have lights that are not what we want, and we're going to be paying for them in perpetuity back to $20,000 a year, if you did the math. And all of a sudden, Pepco we got to buy from the company store. Are they in the business of selling us lights? So we were not that happy. All right, so we didn't get an answer. We realized that this wasn't just a problem for the little town of Washington Grove. It was a problem for all municipalities in Maryland. So obviously, we applauded the decision of the Maryland Public Service Commission to, let's take a look at trying to make a process for municipal streetlight ownership. Come to find out, there is a law since 2007. And my committee is saying to me, yeah, but Virginia, nobody's ever been able to buy a light because Pepco has been dragging their feet forever. 16 years we're talking. Okay.
Well, that's why we're here today. We're
All right,
trying
but
to
let me just
expedite.
finish, okay? I'm self-employed, okay? I attended all of these meetings, right? Everybody else is getting paid, okay? So part of being self-employed is a sense of, is the deal real? That's a big part. Am I wasting my time here? Well, I'd have to say the deal was not real. I spent all 3 meetings. We had another meeting on the 10th of November at Washington Grove. They have made, if we bought our lights today, we'd be paying more for these 7-year-old lights than we're paying now. The deal is awful. It's one-sided. It's disingenuous.
Ms. Casada, if that is the position of Washington Grove, there's nothing restricting you from filing a complaint against Pepco this
I
afternoon.
understand that, but I'm hoping by coming here, because you said we have to come and tell you what we
You don't have to come. Gaithersburg didn't come.
I know, but I'm hoping that you would consider how generous should you be to this next tariff to Pepco. They have failed to upgrade their lights across the whole municipality, Maryland. Everybody's trying to get LED. They have also stopped people who wanted to just do it themselves and get LED. They haven't allowed that.
Some of the allegations you're making are outside of the record, and I won't entertain.
All right. Obviously, they have not kept records of their assets. They went on record at these meetings that said, we do not
Ms. Casada, I'm going to have to stop you. This is a status conference hearing. This is not an evidentiary hearing. I don't need to hear all this.
All right, but let me just say, if Maryland Public Service Commission, can you help us find a real path to municipal streetlight ownership? Because as far as I'm concerned, I got the same answer I got in 2020. No, we'll never sell you our lights. Thank you.
Thank you. If Mr. Tony Ruffin of Pepco made that statement, that would be contrary to state law. Mr. Woodbury, could you please enter an appearance?
Thank you.
Please state your name and who you represent.
Yeah, George Woodbury, LightSmart Energy Consulting, and I'm working for Washington Grove, but also participating with all of these communities.
Thank you. We understand that you're stuck in traffic this morning. Thank you for being here. This is a status conference only. We're not getting into substantive issues today. What would you like to address the commission on this morning?
I provided you all yesterday in writing, through your normal process, some comments in regards to some of the major issues, so I don't need to go into those. They are available to anybody that can access your system. I think you all understand, I'm the national expert on municipal ownership of streetlights. I've helped 140 communities through this process. I wrote the laws in 4 states that allow this to happen. And currently, my company manages 59,632 streetlights in Rhode Island, which is slightly less than Pepco's total service territory, and I do it with a staff of 2. I know what these things cost. I know how it works. I know what the challenges are and how you can make it work. My perception of what's happened over the last several months is this has not been a negotiation. Pepco has taken the opportunity to tell us what they're going to do. They have attempted to placate us during the course of these conversations, but I don't believe there was anybody in the room that had the ability to make a decision.
All right, Mr. Woodbury, I think we've heard that from Ms. Casada as well, frustration. The position of Washington Grove, as I just asked her a moment ago, are you ready to go to litigation then? Or do you want more time to work with Pepco?
I'm willing to work with Pepco as long as they're willing to work in good faith.
Thank you. Mr. Gregor, Staff Counsel, complete the record. Is there anything you'd like to add?
Thank you, Mr. Chairman. The only thing I would like to add is that staff is in general agreement with Pepco and Ms. Ferguson that additional time would be beneficial to the process in order to narrow the issues. So staff agrees that we're probably not going to reach 100% consensus on all items that are at dispute as far as the sale of overhead streetlights. However, I think there is an opportunity to narrow the field of issues at play next time the Commission does hear about this issue.
Thank you. Mr. Gregor, the next time the Commission hears about this issue, should we hold another status conference, or should the parties simply file their contested items with the Commission for resolution?
I believe staff's recommendation would be that the next date certain that the Commission set should be the filing with the issues that have been agreed upon and the issues that are that consensus has not been reached. And then once the Commission and staff has that breakdown of what was agreed upon and what the parties cannot reach consensus on, then we can move forward with some sort of litigated or other sort of process in order to reach resolution on those issues.
Thank you. I suspect we could do this on paper and not require a trial-type evidentiary proceeding here. Do you have a date in mind when that filing should be made?
It appears that the parties are okay with the date in March. If both Pepco and the municipalities agree with that March date, then staff has no issue with that, Your Honor.
Mr. Michael, a March date for filing?
Yes, I'm more than happy to reach a March date. I don't know that it can be done on paper, but we will work toward that goal.
Do you think we need a evidentiary hearing on this?
We're just going to have to see where the issues shake out, Your Honor.
All right. Ms. Ferguson, since you'll likely be filing as well, a March date works for you?
Late March.
I'm under instruction from my client that beginning of April would be better.
Okay, why don't we say, Mr. Michael, Mr. Gregor, Friday, April 7th?
Staff has no objection with that date.
Yes, that works for me, Your Honor.
Thank you. So that is the date of filing. Ideally, you'd be filing a consensus settlement, but more likely than not, there'll be some consensus items and some non-consensus items. The Commission will review that filing. Hopefully, that would be a joint filing between Pepco and the municipalities, to the extent that you can't even agree on what's consensus and what's not consensus. Then make 2 separate filings or multiple if the municipalities don't agree with each other. The Commission will take that up. We will determine the format. If we could handle it on paper, that would be my preference. If we need a live trial, we could go to trial. I've denied my colleagues the opportunity to ask questions, so I turn to my colleagues. Commissioner Richard.
Yeah, I think you've actually covered that quite well, but I did have a couple of things I just wanted to ask, I think primarily staff. I was interested when you said that you think that there's an opportunity to narrow the issues. Are you in a position that you can help the parties? Because I'll be honest, I'm quite frustrated as well that we're not actually resolved today. I thought Pepco was going to try harder. I feel like right now they're being somewhat dilatory and are frustrating. What's clearly, I think, we've been told by legislators is the state policy. And so, and I think it was brought home, a lot of these folks here are doing this, on their own dime, and they're not, supported by a lot of, companies and entities that are paid. So I think we need to be mindful of that. So to the extent you can provide some guidance to at least know where PEPCO is dug in and does not intend to compromise at all, I think that would be probably helpful to the parties so that they can actually get to the point of where they can negotiate and what we just need to plan to take up in April. Is that something that staff is in a position to do?
Staff is always willing to assist the parties, primarily through technical knowledge, but I will note that staff has participated in the general meetings so far. Staff may take a position on certain issues within the filing, so to that extent, there may be some conflict between staff and the municipalities or staff and the utilities as far as how this ultimately shakes out. But as I said before, staff has participated in this process since the beginning and continues and will continue to participate in this process until it concludes. And whatever assistance we can provide, to the extent we can provide it, that's always something staff is willing to do.
Okay, well, I appreciate that. And maybe I see some raised hands. Can I just ask the company, can you be forthright and let the parties know where are you refusing to compromise? Because it seems like we've gone through these status hearings several times now, and what I'm hearing from the municipalities is that you assemble meetings, you take in some information, and then you pronounce edicts as to what you're going to do. So what are you willing to do? What is the company willing to do here?
So I disagree with that characterization.
Well, I'd rather just hear what
we're willing to meet with them and to work through the issues. We got the markup of the documents that we provided them in September on January 9th, and we are reviewing it, and we came here today committed in early February to meet with them to work through all of those red line markups to determine where we can agree and where we cannot agree and bring it back to this commission.
Okay. Well, I'm glad since the October meeting that happened, but we were notified by the legislature, over 40 legislators and all city council in Prince George's County and Montgomery County said and told us that we do not believe the company is in compliance with the 2000 law, and that they were frustrated with how you're dealing with municipalities. So, and then they further charged us at the commission that we need to do something. So we've been trying to do something. We've been having I think we've had 3 meetings last year. And I feel like we're no further along today than we were last time. So, we're on notice from the legislature that we're not doing our job, and I just really, I'm frustrated by that. So, anyway, that's probably not a question, it's just a statement.
We will continue to take good faith efforts to resolve this.
Okay. Yes, I'd be interested to hear from the municipalities. And Mr. Chairman, I do take your point. It is good to have these parties here, but again, many of them are not paid, and Mr. McKeel is going to get his salary. They have to come on their own dime. The people of is it Gaithersburg or which city has paid council? So it's fortunate they're here. But again, I just think that needs to be noted that. The company is at a big big advantage here when it comes to dealing with municipalities. But anyway, please.
In response to your question, staff has participated by attending a number of these meetings, but don't really say they don't say very much. Sometimes they'll ask a question or two, but I think a suggestion of at least authorizing staff to participate in a way that lets both sides know what's a realistic position, or assisting in answering questions about what's a realistic position and whether or not something is real or kind of puffed up, would be helpful, I think. And because right now, I know we ran into this previously, where I would asked staff a few questions, just procedural questions in terms of how do we address these kinds of things. And there was, frankly, a pushback from Pepco that we were talking to them. I'm.
Parties could speak to staff at any time, unfettered.
Thank you very much. I appreciate
And staff's
that.
in the room, so they heard your message. Maybe they'll be more vocal at a future meeting. Ms. Hardy.
I just have a process question. It's my understanding that in the first quarter of this new year, within a few months, Pepco is planning on submitting a tariff for LED lights. And today we heard that within 6 months they're going to have a tariff for converting from HBS, which is what we want to do, to LED, kayak. It's the first time I've heard that, by the way. But so I'm wondering, what about the nexus of that? Are we going to see a tariff proposal that is in sync with what we're talking about or different from what we're talking about? And how are those two things going to be resolved? Because the timing seems to be coinciding, but not quite.
Mr. Michael and Mr. Gregor of staff will address that. Obviously, Pepco service territory, they are moving towards LEDs. You heard there was an item on today's agenda that we addressed that touched on that.
Right.
I leave it to the utility to ensure that whatever process comes out of this negotiated discussion, compromise, or litigation, we'll address that concern. But that's not something we need to address today.
No, I just wanted to
No,
understand. how
we should be aware, situational awareness of
Right.
other changes to its street lighting tariff. Yes.
Thank you.
Commissioner Bubar.
Actually,
Oh,
just,
sorry.
I'm
Commissioner
sorry.
Richard.
And I'm not going to go through all my questions I did since this is just a status hearing today. But I did also want to just weigh in on the idea of a paper versus live hearing. It just seems that again, a live hearing is very resource intensive. Pepco has those resources. They have someone paid to come here, but to the extent we can do this in paper, I think that's probably fair to the municipalities, and I hope that's the direction we go. And with that, I'll
Thank you. Commissioner Bubar.
Thank you. Thank you. This was all very helpful. I really just have a process question about next steps. And this isn't, I don't think, for the commission to dictate, but will these meetings take place en masse? Like everybody will be in the meetings, or individual meetings, or just want to make sure we're getting off on the right foot with
In
this.
my opinion, at this point, we need people in the room from Pepco's side who can say yes or no, and we know that they have power to negotiate. Up to now, that has not been the case. And also, I think a smaller group where those who show interest to be part of that negotiating team would be more useful.
Thank you.
100% agree with that, and that is our goal in February.
Commissioner Linden.
Thank you, Mr. Chairman. So since this is a status proceeding conference that we're looking at moving forward, I just wanted to make sure that the parties, particularly the towns, have followed the requirements in the statute. We're talking about having a further proceeding down the line, just to make sure that everybody's done that. You've actually submitted something in writing to the company requesting the information necessary to purchase the street lighting in whatever structure and approach you'd like to do so. I believe that was a requirement in the statute. And when we talked about that at one of our press meetings, I can't remember which one it was, but I remember asking the question. And I guess, Mr. Michael, I could ask you if you've received any written requests.
That has not happened, and my understanding of what we were doing here with respect to the pole attachment agreement and the purchase agreement, those are model agreements, right? That the municipalities wanted to know what our charges are, what those agreements look like. So we're trying to work to get a model agreement that, has a large amount of agreement too. We would get a letter, and to your point, Commissioner, follow the statute, do what's required by law. But we have not received recently letters from Washington Grove, Chevy Chase View, Chevy Chase Section 3 to purchase the streetlights.
So I don't have a copy. I was trying to find it online before before the questions cycled to me, but I didn't get to it fast enough. But so I'll leave it to each of the parties to take a look yourselves. I know you've verbally requested. I guess all I will suggest, and I know you have questions, but all I would suggest is that you take a look at the statute that authorizes you to purchase the street lighting. It does have some procedure in there about what's supposed to happen and how it works and where your rights become effective and when they don't. And so certainly Mr. Michael appears, he's a learned counsel. He's been around for a while, so I'm sure he's looked at it. So, and staff is also prepared in that way. So I suggest you take a look at it. It is online and free. I just didn't find it yet. I have the commission statute here, but not the state government article.
Thank you for that reminder.
Just one question. For example, as was pointed out, I sent them an email on September 13th requesting certain specific information that I've never received a response for. So when you say in writing, does that mean it has to be in a different format other than email? Does it have to be a formal letter? Can we define that, please?
Well, I think your questions appear to be more of an interrogatory format. So you're asking for certain information within this process. I was speaking more to what the statute says in terms of how a municipality may want to initiate the rights that it has under statute to request purchasing of street lighting. There's provisions in there that I won't go into now that you should pay attention to.
If I might for just a second, various requests were made, and before there would even, this is where we started, because there were requirements at that point that surveys be done that the municipalities had to commit to paying for to even know what they were asking to purchase. So that's part of the issue that we came in about, was having to commit to paying funds before you would even know what lights were in your municipality, at least according to PEPCO. So that's where we started. But and so it's very difficult for a government to commit to saying, yes, we want to purchase these lights, when PEPCO would not start out with even confirming what is out there. That is an issue. And that's something we've been finding out through this process, is that PEPCO does not have records of what it owns, and is attempting to put off on the municipalities the job of actually figuring that out. So that's where we started.
You've highlighted that issue, and
Okay.
we're not here to get into the substantive issues.
Understood.
But if you cannot agree on that issue because PEPCO has poor management practices and they don't have a complete survey, put that on the list of issues that you will be litigating.
Will do.
Ms. Cusada, quickly, please.
Quickly, I don't see the advantage at this point, as she has said, to make that offer when there is so much in limbo. Make an offer
Then you litigate that offer.
Okay.
Right.
But to be chastised that we haven't done that,
And
it seems to be, I mean, not chastised, but I don't know what the term is, but, we're not in a position now to make that offer because of the circumstances we are now in. So I do think that's all.
Thank you. Sorry.
That's all right. I've seen this issue for a long time, as you've noted before. So I guess all I'll say is that if you're going to move forward with litigating it in the future, you should take a look at the statute to make sure you've done what it suggests you should do in order to initiate your rights. So, at least at this point, from this spot, that's as much as I can say. So.
Thank you.
Finally, Mr. Woodbury, to your point on communications, you could communicate however you would like to PEPCO, in writing, via emails, via interrogatories, or data requests. It'll be incumbent on the utility to respond. If they don't respond to your liking, then that will be a contested issue that you could raise with the commission. At this point, the commission will expect the parties ideally to file a joint filing on Friday, April 7th. If the parties cannot reach consensus on a joint filing, they should file individual filings by that deadline. This hearing is now adjourned.